next term is talking about. And we know, I think, why we are all talking about alternative justice system from a psychological perspective. It is really in the best needs of the mental well-being of the child. We safeguard everything when we safeguard the child holistically. Because we know when a child is entering the justice system, either because something really bad has happened to them and therefore they need to be protected, or they have been apprehended because they have engaged in an act of commission, which is in contravention to some laws. Behind that is a map of very invisible things that we do not see as actors in the justice system, because maybe we don't have the training and the capacity to detect mental health needs in the child. Or because our focus is on law enforcement and what the law says and what the procedures say. So, just taking into cognizance the fact that every child that we meet may have some pre-existing psychological problems is one thing. The other thing is contact with the system itself is sometimes enough to have the child look into the system very healthy psychologically to come out of the other end with some issues. And so that is why in our country, I think, we have been able to make some advancements in acknowledging the role of psychologists. Because these are mental health professionals who can be able to tell us, this child, in my assessment, this child is behaving in this way because they have gone through some traumatic experiences. Or this abuse, this sexual abuse, this physical abuse, this severe neglect has caused this child some form of trauma that needs to be treated. This child is forever, frequently arrested because they have attention deficit hyperactivity, which means that sometimes their brain is so busy that they do things without thinking about the consequences. And that is something that if we look at it from a criminal lens, we might not see the underlying issue. So these are just examples of some of the things that children come with to the justice system. And we know that the law is a social force. And the law is manifested in the procedures and the processes that we have in the justice system can either be therapeutic or it can be non-therapeutic. And those of us who work in the justice system know that some of our processes are very good for the mental well-being of children. Some of the processes are not good at all. And there is nothing we can do about that, We have, as you all know, the Children's Act that I think there was a lot of consultation of all the stakeholders. And you agree that the justice system, this piece of legislation best represents the needs of the child. And so in the words of Professor Wexler, the developer of TJ, or therapeutic jurisprudence, which says that the law and its processes and procedures and how we interpret it as actors can actually be used to uphold the mental well-being of children. This Children Act, I look at it as the new wine. I think borrowing from the metaphor of new wine, old wine skin, it's the new wine. It has come with feature and diversion, that we again, those things were not there in the previous Children Act 201. And this new wine, this new bottle, the law is the new bottle, has brought it the new wine, which is psychologists and other people. So as a psychologist standing here, I represent the people who, the part of the new wine, whose child has access to justice, to assist the justice actors in being able to understand this child and sometimes make those very critical decisions. So the inclusion of counselors and psychologists is premised on the idea that access to justice entails the emotional, having all the emotional, social, psychological issues given prominence and attention. Not just what the child has done, or not just, in the pursuit of having the perpetrator be punished. So, our act that we draw, mandate is not very old, 2016, regulates, the work of counselors. So, given that, counselors and psychologists also have their own mandate, and then combining that with the new laws that we have, like the Children's Act, then that gives them more legitimacy. And it is my appeal to the justice actors to use the services of counselors and psychologists. Even the NGOs here, I hope that you have employed them in your programs and your projects to be able to advise when you're designing those projects. Where is the mental well-being of the child? So this is what we do. A lot of screening and assessments of children, psychological screening and assessment, which of course results in, that report that says this child, after looking at them, these are the issues that they have, and these are my recommendations to the police officer, to the children officer, to the probation officer, to the court, even to the prosecutor, even to the child who ends up in a correctional facility like the prison, And I'm glad, the prisons have employed psychologists, the children officers. Provision of psychological report is very important. I think it does at every decision point, from the point of contact with the law, which is at the police station. Those assessments can really help the justice actors to make the right decision. I think, as one of the people who are in this system myself, the decisions we make about children, we need to take them very seriously, because I know what I write and what I say can change the trajectory of that child's life forever. Like, for example, there's a provision of saying by saying that this child goes to Boston institution, which is a youth detention facility. There are so many things that we change in that life, so I need to really think through this decision. As the court is making an order that this child stays with this parent and not the other one, in the absence of a psychologist's report, that could also change the life of this child forever. So inclusion of the psychologists and counselors is so important because of those things. Sometimes we go to court to provide support of our reports as expert witnesses, recommending removal, hospitalization of children. All these are things in the Act. In the family group conference that we shall be talking about as one of alternative forms of justice. When the Children Act was being, when there was public participation, and it was in Parliament, we as the child therapists went there and said, the family group conference, the list of the actors who should be there is no counselor here. So who's going to speak for the child and say, the way a family group conference is supposed to be run, the typical way, I don't know that we are going to have a simulation of that, is the family of the child and the family of, let's say, if it's a child in conflict with the law, and the victim, they sit and talk. The child is waiting outside. Decisions are made. Maybe a teacher is there, the chief is there, Makumi, those village elders are there. And there's a point in the family group conferencing where we call the child and say, miss their time with the family, but at the same time, they will get an opportunity with the help of the counselor and the psychologist to explore how come they are, what they are. And the family also to be drawn in the treatment plan of that child, now that they have been placed under the care of a counselor and psychologist, to be able just to look at it. So in conclusion, what I have said is that counselors and psychologists have a very important role in the child justice system because they can help to buffer the child against the adverse consequences of contact with the system. But again, they can also help actors in the justice system to be able to make the right decisions about the child. We also know that even being in contact or in conflict or in contact with the justice system sometimes isn't the worst thing for a child. As a counselor, I know that sometimes that is the best thing for that child. Why? Because there will be so many other things that can come in terms of helping the child. We have had children who are just arrested maybe for stealing, but then you find there's so much trauma in that child's life, and they had not gotten any help. Even the parents did not notice. The teachers did not. We all labeled this child as the village thief. They come into the justice system. The court places them under the care of a probation or children officer. They get counseling, and that child's life changes for the best. So even as we say that, I think we also acknowledge that sometimes coming to the justice system helps save that child. Thank you.
You've done well.
Okay. We have the State Department for Children Welfare Services, represented by Ms. Nyaranga Odunjo, and she's a children officer with the State Department stationed in Nairobi Children Court. She works as a liaison officer between the State Department for Children Welfare Services and Judiciary, vis-a-vis the children in contact with the law, and she will be giving us a very good account about how she's working with children in the community, so that we can see what the picture is in terms of children in conflict with the law. So let's welcome her, please.
Hello everyone. My name is Nyaranga Odundo. I am a children's officer based at Nairobi Children's Court. The title that they have given me is liaison officer, which I really enjoy. That means I get to work with everyone, the judiciary, the ODPP, other children officers across the country, and provide services to children directly at the court station. So as concerns matters diversion, of course, I think maybe all of us by now have had access to the Children Act itself. So I will speak to specific instances where this has been used and has assisted children in the court. So when children are in conflict with the law, of course, there is the legal procedure that is followed, informing a children officer at the ground level so that an assessment can be provided for that child. At Milimani Law Court, all children in conflict with the law have what is called a preliminary inquiry. That is, if the ODPP decides to charge the child and they end up in court, a preliminary inquiry must be conducted, and that is when the court and everybody involved. So within a preliminary inquiry, the children officer will be there, probation officer will be there, the child themselves, their guardian, their legal representative, the person who is affected by whatever the child has done is also there. And together they sit down, they look at the reports, they do an assessment and see whether it is possible for the child to go through diversion after plea, because of course there's diversion before plea and there's diversion after. So these assessments are done under Section 218 of the Children Act 2022. And what that has really helped children with, especially at the court, is children with special needs. Because at the end of the day, no matter what the child has done or is suspected to have done, that is a child, right? And that is the attitude that is taken by children officers, by the judiciary, by the court station that is Milimani Children's Court. So in specific instances we've had where during a preliminary inquiry, then the court, will go over the children officer's report, the probation officer's report if it is ready, and many times they require an assessment from someone like Dr. Mweni, who is a professional child psychologist. And we have had instances where, for example, a few months ago, we had a young boy who was brought into court for attempted murder, and that is a huge deal, right? But because of the intervention of the court, the children's officers, the probation, and the medical professionals like the psychologists, the boy was diagnosed with paranoid schizophrenia. And that is why he had gone through that process, because he had not been diagnosed before, and he was not able to get the medication and assistance that he needed. So that child was, yes, a child in conflict with the law, because what he did was in view of many people and with many witnesses, and everyone would have said, yes, he came in and he had a knife and ABC. But because of that intervention of the Children Act and all those different actors together, he was able to get the assistance that he needed. Because without that assessment, without the professional opinion of a psychologist, without the view of a children officer who requested that assessment, without the court following through the procedure of the preliminary inquiry, that child might have ended up in incarceration. He would have ended up, in an institution where maybe he was still not getting the help he needed because nobody had gone through the processes that he required. So also we have the diversion that is being spoken about in section 230, and the different levels of diversion. Now, each of these levels of diversion, there are some that have what we call maybe supervision, and the supervision might be through the court, by a probation officer, by a children officer, and how are these people equipped to assist with that process of diversion? Because diversion is envisioning that this is a child who has the opportunity to reform, to change their habits, because the first step of diversion is that the child accepts that what I have done is wrong, and yes, I have done it, and I want help to not do it again, right? So that's the first step. And all these different actors, from the children's office to the probation office to the psychologist, they all come together in order to assist that child to not come back again. Because it's the point of it is to help this child reform, to help this child change their behavior, so that they meet you once and hopefully never again. Of course, they'll have maybe a long-term interaction with their psychologist, but as a children officer, the ideal situation is where you become redundant, because that child is safe and happy in their home and they're doing the right thing. So I won't say a lot because I know I am taking up somebody else's time, but I appreciate the time that I have been given to speak to you. I encourage everyone to visit our child-friendly office at Milimani Law Courts. We are on the 3rd floor, right next to the stairs. We are there every day. We love visitors. But our clients are children, so if they are children, we will kick you out. Yes. But when we have small gaps, we really welcome visitors so that you can see that the work that we do and how we coordinate with all the different agencies. Thank you so much.
Thank you so much. Let's give another round of applause. Okay, so we'll get into the panel now. I'd like to welcome the panelists who will be with us. And the panel discussion will be on plea bargaining and diversion. Let's have you come to the front. We have Mildred Aru. Mildred. Let's clap for her. Then we have Ms. Linda Ndambiri from Office of the Director of Public Prosecutions. Then we have Ms. Ann Thiomo from the State Department of Children Welfare Services. And we have Mr. Sonka from National Police Service. And we have Ms. Eri Matas Suzuki from UNICEF. Okay, thank you so much to the panelists for availing yourself. I was just asking myself, we have children in the room, And I'm wondering if they understand what we are talking about. That's pre-bargaining and diversion. Is there any child in the room who can raise up their hand? They can give us any idea or an idea of what we're talking about. And if you really don't have an idea, please be honest and say, I don't know what you're talking about. Any representative from Total News? Any child representative? What's your idea? Yes.
My name is Carmen, and I have no idea what bargaining is. I'm trying to figure it out, but it's not kicking.
Yeah, thank you. Thank you for that. Thank you for your honesty. Any other child in the room or young person? Yeah. Okay, anyone else who doesn't know what we're talking about, you know, it's very important to have context. Yes? You don't know what we're talking about. Yeah, so it's good because you might be in church and the preacher is preaching and you don't understand what they're talking about. So it's good to have context. Thank you so much for being honest. So we are talking about plea bargaining and diversion. Yeah? Oh, sorry, yeah. Yes. Okay, all right. Thank you so much. But at least we are on the same page that we're in the World Congress on Justice for Children, right? And this year is the 5th World Congress on Justice for Children. And we'll be focusing, or the focus for Kenya satellite event. So there are people in Spain right now. They are having the same conference on justice for children, and it's different countries in the world that have gathered in Spain. Kenya is actually represented there by Dr. Moses Maraga, who is the executive director of the National Council on the Administration of Justice. Then the countries have the option of also having satellite events, and there are several ones in Africa. And I think in East and Southern Africa, it's Kenya and Ethiopia having a satellite event. So we can clap for ourselves, that's a good thing. This year, at the global level, TDH is also supporting the convening at the global level and in Kenya as well. So the focus for Kenya's satellite event is on alternative justice systems and diversion. So I can read the theme to us. It's integrating formal and alternative justice systems to strengthen child justice in Kenya. So that is the theme for today. I hope you're okay till there, right? So this panel discussion is going to be focusing on plea bargaining and diversion. And the reason why we are talking about plea bargaining and diversion is because there are alternative measures on how to turn away children from the justice system. So you know we have 3 categories of children in the justice system, right? We have the children in conflict with the law, children in contact, and I want to say children who are witnesses, but they are also regarded as children in need of care and protection. So we are focusing more on children in conflict with the law, so the ones that have broken the law. We are good till there? So plea bargaining and diversion have been defined in the law. Diversion means the intervention and programs designed to divert children from the criminal justice system, and diverting is just turning away. When you see a diversion on the road, it just means turning away. So it reduces stigmatization, or how the community sees them. It identifies children at risks and connecting them with appropriate support services, providing programs and support to children who have engaged in offending, and reducing recidivism. Recidivism is when a child comes back into the system as an offender. So, you know, sometimes you make a mistake, you go back, you make the same mistake or a different mistake, you come back into the system. So that's what we call recidivism. So that's diversion. Then, are we okay? I'm doing this for the non-practitioners. Is that we're good? Okay. So that can be easier even for you to ask questions. Then I'll talk about plea bargaining, just to define, plea bargaining involves a negotiated agreement between the prosecution and the accused. So they talk. And then where the accused pleads guilty to a reduced charge or receives a lighter sentence in exchange for a guilty plea. So plea bargaining is haggling, negotiating, just the way you go to a market and you tell them, I want this for a lesser price, right? But this time it's an offense. A child is told, okay, for us to, and Linda will correct me if I'm wrong, for us to reduce this charge, you are open to voluntarily say that you're guilty of the offense, and then we'll give you a lesser consequence for what you did, right? Okay, so Linda, you can expound on that more. But this is the panel, and I wanted to reflect on some data before we start on the questions, so that you can see what the situation is for children in the justice system in Kenya. So we have 3,000, this is data from the NCAJ annual report. We have 3,620 children in conflict with the law who are admitted in remand homes between 2023 and 2024. 2,942 exited, and 668 children remain in remand homes. 1,881 children offenders were handled by, I'll change that, State Department for Children Welfare, and then 213 cases were resolved. So, and in that financial year, we had 1,663 active cases. And this is the situation. So that's the map from the annual report, and it shows the number of child offenders. The red is danger zone. You can see the numbers are very high, followed by the green, and then so forth. And then these are the ways or interventions that those matters were handled. So you can see 38% were judicial orders, police diversion was 26%, there was professional counseling 21%, and then supervision and court orders was 15%, and this is according to the NCJ annual report. So we have representation from different agencies in the justice system. According to our Children Act right now, there's supposed to be a lot of coordination on justice for children. And sorry, I want to get the questions. So I think we can ask the first question to the Directorate of Children's Services on what your role is on diversion and how you think you can coordinate with other agencies with regards to diversion.
Thank you, Rosie. Like I said, my name is Anne Piamo from the Directorate of Children's Services. Yes, we acknowledge that diversion is an international principle. Our directorate plays a key role when it comes to diversion, because before the court diverts the child, it must be clear on the pathway they want to take for that child. We are therefore required to do a social inquiry and carry out an assessment of the child. We should be able to interview the child. During the assessment, we will look at the offense committed by the child, what led to that offense. Is it peer pressure? Is it parental neglect? What it is, and then advise the court. Thank you.
Thank you so much, yes, and State Department. And we already had a whole presentation about how it's being carried out at the courts. So my next question is to Legal Resources Foundation. Legal Resources Foundation works a lot in the grassroots. And the question is, how is the landscape of plea bargaining and diversion? And how do you think it has evolved in Kenya, especially for children in conflict with the law, since LRF has really worked in Kenya for a long time, especially on legal aid?
Thank you. Legal Resource has been in the sector for quite a long time, not me, but yeah. I'm a child. Anyway. So Legal Resource Foundation Trust has been in the sector for quite a long time. And from a civil society perspective, we really want to have children So what I can say about diversion in our country, it has, yes, evolved. We are glad that we are where we are today, though we are not where we're supposed to be, because we started piloting, okay, we piloted the first diversion activities in 2014. We introduced that in 6 counties: Nairobi, Nakuru, Kericho, Kisumu, part of the countries. And the work that happened at that particular time was not really embraced very much easily at that particular time, which is a concern for us because we feel we need to have more of our children out of the system. And what we've heard from the previous presentation on counseling and trauma that children go through in the justice sector, we find our children coming out of the justice system more skilled than when they came into the justice system. So what I can say right now is, yes, we have some way of, communities accepting and embracing this, but we need to do more. We need to capacity build. Surprisingly, we go to certain counties and even the OTPPs are still not aware of the version, what exactly this is and how it's supposed to play that role. So for me, I think there's need for a lot of awareness in this aspect. Talking to our communities, for them to also appreciate what is this thing called diversion. Is it a way of driving ourselves out of the system for our children? Because private conversations also come into play. What we need to ensure that even our courts embrace this process. I know most of the magistrates love sitting in those courts. Most of the time we challenge them. Don't you see the need to have this 80 offenses out of your way so that then you can deal with the heavy and serious cases before you? So how can you have these children in our system? So for me, I think we've come a long way, but there's need for a lot more to be done. Capacity building and of course financing the process, because we find challenges, of course, when it comes to handling these children. You are diverting a child, then what? So what question comes in? Are there treatment plans? Who finances these processes? Who is responsible? So for me, I think there's a lot more that we need to do to ensure that diversion really works for us. It's not just in paper, but we have the really nitty-gritties about this process being implemented by the different agencies.
Thank you very much. I just wanted to add that even as we look at diversion, remember a child must admit that they have committed an offense, but realize, just with an example, a child comes to court in the morning and the next day they're there with the ODPP. So the children are also not very well sensitized because, I mean, you can imagine telling a child, please just say that, admit. So they don't know which way you want to go. Do you want to crucify them for that, or do you have good intentions? So the parents and even the children are not so much aware about it. So we need to do a bit of sensitization when children in conflict with the law and come to court. Thank you.
Thank you so much, Anne. I'll move to the Office of the Director of Public Prosecutions. And we note that the ODPP has the diversion policy, the diversion explanatory notes. We have the plea bargaining rules, plea bargaining guidelines, and the CPC that guides in these two processes. So Linda, the question is, what criteria do you use when considering the children in conflict with the law for diversion and plea bargaining? And if there was any clarification in terms of the definition, you can also clarify.
Okay, thank you. So in terms of the ODPP, yes, we do have the policies, diversion and plea bargaining. Plea bargaining is essentially a negotiation between the prosecutor on one hand and we call the subjects in this regard because they're children and their legal representative. The ODPP does not negotiate directly with a child because they have to be represented. Most times plea bargaining is done for serious offenses. So we have murder, we have robbery, violence. So where we have a murder charge involving a child, we might watch plea bargaining. To plea bargaining mostly because, of course, of the time, maybe we want them to go back to school. Maybe they are really remorseful in terms of what they did. So we do reduce the charge maybe from murder to manslaughter, if it's robbery, violence to simple robbery in terms of plea bargaining. Diversion, as I think Rosaline has adequately explained what diversion is. For us, in terms of ODPP, what really is the criteria? So the criteria for us is contained within our national prosecution policy. We have the general prosecution guidelines. together with the diversion policy and the diversion guidelines. These ones are new. They came into place in 2019. So that is when we started the process of diversion for good PPP. So what we look at the age, we look at the mental capacity of this particular child, we look at what are the alternatives. Of course, we also have to look at the offense. What offense has this child committed so that we know we will offer either diversion or we will offer plea bargaining. If it is, of course, like the offense, probably Naraka talked about the alternative, attempted murder, isn't it? Probably it's not an offense we would try to finish at prosecution stage. We probably want to take it to court because it is a felony offense. The penalty involves, it's a higher penalty, so we probably want to take it to court for purposes of prosecution. And even in that particular case, we did prosecute. Actually, the child pleaded guilty in that particular case. But yeah, we look at also previous records. It might be a very simple offense. You might not think it's stealing, isn't it? But you also have to look at the community. What is the community saying? Especially if the child has been stealing. Of course, we look at the children officers report, maybe the child is hungry, but probably the child has another underlying issue. So we look at the children officers report, and this is a matter either if we might give one or two diversions for this particular child, but if it escalates, if the options that have been given are not really assisting this particular child, we will charge this particular child. We have to look at public interest. The public interest differs from region to region. Nairobi stealing might not be a very, I think, high offense, isn't it, in terms of children. But you might go to somewhere like Kakamega, isn't it? Maybe because of the poverty index, stealing is a very serious offense for those particular people. So we have to look at this child depending also with the community. So in terms of the considerations for us to provide a diversion, when we look at the policy, we have the acceptance of responsibility. So this child, it's not really a plea of guilty for us, it's just an acceptance that yes, I did this offense and I wish to have a second chance. We have sufficiency of evidence. These children who are in need of kind protection. I'll not offer diversion to a child who is lost. They have to have committed an offense, isn't it? For them to be considered a child in conflict with the law. And also you have to look at the sufficiency of evidence, isn't it? You can't just, just because you've been brought for a file, you see you're diverting, and the evidence is not sufficient. So we also have to look at the sufficiency of the evidence and the public policy reasons to instigate, as I've said, depending on the community, depending on the circumstances. An offense in Nairobi might be a serious offense probably in Kisumu, that probably in Nairobi we might not consider it a serious offense. So what are these public policy reasons? So I think if you can have a look at our diversion policy and guidelines, you can see what really happens. And we anchor our diversion on Article 157 of the Constitution, which talks about the ODPP being the person who institutes and undertakes criminal proceedings. So they have the state power, they have the state powers of prosecution.
Okay, thanks, Linda. And just touching on the role of ODPP and charging, I know the police also have a role in charging. So I welcome Mr. Songa to tell us if the police have a role in diversion for children and how they have already undertaken diversion, if they have.
Thank you, Rosalie. My name is Colin Songa from the National Police Service. First of all, let me begin by saying that nowadays police, we don't have a role in charging. Nowadays we just gather evidence and take the file to the prosecution, who will determine whether to approve or not. So currently within the National Police Service, yes, we have a role in diversion, and our key role comes in, first of all, in identification of the offense. So our key role is towards the investigation, arresting the child, and it is never an easy task. That is what pains the police to be negative, especially being used to go and arrest the child, isn't it? But sometimes we don't arrest, we just summon them through their parents to make sure that they facilitate the child to come to the police station. But we don't go outside there key role comes in identification of the offense, looking at the nature of the offense, gathering all the evidence, visiting the crime scenes if it involves capital offenses, and making sure that we are able to compile the file and take to the audit. But sometimes we also do diversion, but I stand guided by Linda. I don't know whether it is within the diversion guidelines, because sometimes parents bring children to us just to warn them, to caution them, again, which to us is not good, just bringing children to the police station to caution them. And I know here, then we have parents who always believe that when a child commits something, you take them to the police station, or you threaten them that I will take you to the police station. And yet police stations are supposed to be a center of operational creativity, and we also have child-friendly services like child protection units, though they are not enough, but nowadays we don't envisage a situation where we are going to keep children in lock-up cells. So we have child protection units, but again, they are not enough. We have 45 child protection units in Kenya, but out of these 45 child protection units, only 18 are IB. And we are also, we just want to encourage the non-governmental organizations that whenever you want to support any initiative, you need to come to police headquarters so that we can give you a plan. If a child has got to enjoy those child protection unit services, then it must cut across, it must be equal. Not that in Kakamega, we have a CPU that is 3 meters by 3 meters, and in Buruburu we have a CPU that is 10 meters by 10 meters. So we want children who are going through the system to enjoy those equal services. Now beside that, we also play a key role in referral. There are cases where we refer to children's services, to probation officers, just to assist in terms of collecting information and being able to advise the child. So those figures are very much.
Thank you so much. I think we can see there's a coordination aspect that's needed on plea bargaining and diversion. I think plea bargaining more leads with the ODPP, but for diversion seems that there needs to be a lot of coordination. And my question is to Eri under UNICEF. Since UNICEF has, that bird's eye view and is placed in different countries in the world, how do you see Kenya's approach to diversion as compared to the international child justice standards, and what advice would you have from the global level?
Thank you, Rosie. So I'd like to mention a couple of things regarding the good practices from the Eastern Southern Africa region. And if you're interested in, we have a small publication on that to capture different diversion model in Eastern Southern Africa region, which I can share to your NCG. So one is data and monitoring, and also that leads to accountability. Then, so we have huge effort we see for the data, but data in justice system is generally a challenge. Then we don't know probably how many, probably the project level there's probably data, but how many are diverted, what was the result, how many children came back after. So that's crucial. So for us to see how diversion is taking place. Then I'd like to refer one example of Zimbabwe. So they have done quite strong, good monitoring evaluation. So they can clearly see how many recidivism, so how many children be committing of offenses, how it was reduced, they clearly tracked it. So that's one thing we can do. Then two, Kenya. So always policy and law environment is quite strong. So most importantly, we have Children's Act, National Strategy for Justice for Children, also stipulates diversion. Then some agency has, of course, ODPP has very strong diversion policy. Then we also have diversion toolkit. As far as I understand, that was not implemented. We all have all of these, but my observation as UNICEF is like, they are not necessarily coming together. So we have all the actors, super important actors here for diversion. But roles and responsibility, so when it comes to diversion, is not fully stipulated so in any policy. So that also doesn't help to hold each agency accountable for their own roles and responsibility. So this is one of the reasons we've been supporting under the leadership of Justice Maseka, so to come up with national diversion policy framework. Then couple of, I'd like to also mention a few examples. For example, so the police diversion, level diversion, Malawi and also Zambia, Uganda, so they have very specific diversion mechanisms for targeting the police. Then also, diversion is not about power, right? Diversion is about regulating and making it systematic for the existing discretion of each agency when it comes to diversion. So I think it is very important for all the actors to come together, and also DCS, if there's no children's officer who does social inquiry, it really doesn't work. But children's officers, as you may know in the field, the number is a challenge. So they are really, really overstretched. So each agency has also different challenges, and it's very important to come roles and responsibility of different organizations. So then that also eventually leads to the coordination.
Thank you so much, Eri. So I think we've had some of the best practices, so we're able to see what Kenya might borrow or what is being done right, what is not being done right. I understand, yes, we have a new law, and when you have a new law, new provisions, there's a big change, then of course we have to come back as agencies and have a consensus on how to move forward, especially with regards to coordination. My question is to Mildred. Based on what Eri has mentioned, what do you think are the gaps in implementation on the ground? And what things do you think the agencies should be considering with regards to diversion as we move forward to developing the national framework?
Just to mention that from where we sit as a CSO, what we are seeing is that we need to have structured communication amongst the different agencies that are implementing diversion, because that is missing currently. We also need to have clear protocols. What are these roles that different agencies need to play to ensure that we have a seamless, connection and processes that take place, because that is also another challenge we are seeing. Because a child has been diverted, where does this child go to? From the institution where that is the gap, and for me I think that's something that we need to really look into. We also need to look into technology, and especially timely dissemination of information or sharing of information. That is missing, and I'm happy that in Nairobi and Honorable Kigosi has been a key player in this aspect, where we have, assisting or we can go to tell where is a child in the sector. So for me, I think that is something that needs to be taken across board. How do we embrace technology to ensure that we have timely information on the children we're assisting, where they are, where are we seeing some challenges, and how we all need to come in and support. Then of course we need to employ visual trauma approaches that need to speak to our children, because it's an issue, it's something that has been embraced, and I'm happy that different laws that are coming up are already taking into consideration this aspect, but then how can we take this ahead by ensuring that it's structured, all institutions are employing it, and it's not just left for specific agencies to consider this across board. And she has given us a good thing that we need to ensure that we have psychologists or counselors in our different programs levels to ensure that we incorporate counseling and trauma approaches in that regard. I'm happy we have a child justice strategy, but then how do we take this to the next level to ensure that even the government now funds this process, because we need finances to ensure that ODPP have the structure, the children department have the structure, probation have the structure, police are also financed to ensure that their role is delivered and able to complement. Of course, the issue of mirroring each other and ensuring that we all play our different roles, because we are intertwined. If I do not play my role, it means ODPP will fail, the department will be failing. So So how do we come together and ensure all of us play our different roles? So this probably when anchored in such a law or a framework, it will be able to help us seamlessly, deal with diversion in our country and ensure that our children in all their spaces, whether in Nairobi or whatever county they come from, they're able to enjoy this specific service equally without discrimination.
Yes, you can add.
Thank you. I just wanted to add on to what she has talked about. Like Judge said, we need to have it seamless, but again, our children are going through the version, but sometimes there are no programs. So I was even talking to some of the children officers and saying, okay, fine, so where are we diverting to? So we need to strengthen our programs, we need to establish proper programs. Supervision still remains a challenge. I know the children officers have a role there and other actors, but we need to strengthen that. I think Gloria has spoken about having it structured. Justice talked about that, so that's very important. But to me, I see it must also be well resourced, and again, sensitization. No diversion, how the community out there looks at it. It's like bail. Okay? So somebody commits an offense, they go to court, they give a bail, and the next day they're out. But the community doesn't understand that. So they're saying, oh yeah, this one stole yesterday and now he's going again. So it's the same thing with a child. So a child has committed an offense, they've gone to court, the case has been diverted. But the community now says, okay, so the judge was brave, the magistrate was brave, the children officer and Kula Pesa, and that's how the community looks at it. So we have a big role there to just make sure we sensitize the community so that they understand what the action is. Thank you.
Okay, I'll move to Mr. Songa. So we have a new law on the Children Act, and it outlines 3 levels of diversion. So it also expands the definition of authorized officers to include the police. What do you think, moving forward, on implementation of diversion? How can the police support implementation of diversion in Kenya for children matters?
First of all, we need the police. We need to improve on child-friendly services. Currently, we have initially we had 406 police stations in Kenya, but the inspector general said 799 stations, meaning that now we have about 200 police stations. As I said before, we only have 45 child protection units, which even does not form even 3% of the total number of police stations. So we need support in establishment of the child protection units. I know within the government there are challenges with the issues of budget. We've done reports, but sometimes maybe unless BCS comes in to push to make sure that we have enough child protection units. Secondly, we also need training and capacity building of police officers to enable them to respond effectively to cases of children, and more so on diversion, because some may not understand, some may be coerced by the community, and yet all action must be in the best interest of the child. So we must remain neutral at all points, and we need the support and make sure that police officers are able to undergo training. Then third, from our response side, again, we realize that we don't have any SOPs guiding us on how we should actually initiate the diversion. So maybe we can look into that and develop SOPs, maybe for all the service providers, just to make sure that they seek the support right from the point of contact, maybe up to the prosecution at the court level. Thank you.
Okay, thank you, Mr. Songa. Yes, and
Yeah, but we had, thank you. We had developed the toolkit on NCJ. I have a copy, and we could use that. We put it in before the Children Act. The toolkit has very good steps, what to do, what's the role of DCS, the role of police, and so on and so forth. And as we saw, there's a piece enough. This is how the toolkit is not well implemented. My brother here has spoken about the establishment of CPUs. If you look at section 64 of the Act, that mandate lies with children is provides technical support. That you can come give you a small room. And I like to know, but I'm just saying that mandate lies in the ID section 64 of the Children Act.
Thank you. And to note, there are two
Maybe
two
just
units.
to add on that,
Yes.
Rosaline knows where we are coming from. And Rosaline has been in our office several times trying to push for that. Even within those CPUs, I want to assure you, we don't have any budget for CPUs. We only feed children within the CPUs with prisoners. And sometimes we don't even look at them as prisoners for us. Yes, so we just need an additional budget for that. Sometimes if you ask the IG to push at this level and maybe security is extremely, we need to prioritize children matters, and at some level you may find that maybe we are not giving priority to such issues. So if you push from your end and other departments, it becomes easier for us to implement.
Okay, thank you. And to note, there are two units, right? There's the special police unit, which is the police service, the human resource itself, and then there's the child protection unit, which is the facility to hold children separate from adults. So I think first step would be to advocate for the special police unit so that they can have the capacity to handle their children. And if we have that, at least even most of the children will not have to be put in a child protection unit or a facility, especially if we can have diversion at the earliest instance for the child. So let's move to ODPP. The question is, Linda, you talked about the mandates of the ODPP, especially the constitutional mandate. So the question is, when it comes to children matters, the best interest of the child is the first consideration. And we have the Children Act now that has a principle on the institutionalization of children. And I think we are all aware that when a child has to come into the system and go for trial, they will have stayed in the maybe a cell for several days, or ideally a day. So what do you think is the most child-sensitive way of handling children, or what reservations do you have as ODPP when it comes to handling children using alternative ways like AJS or diversion? Any reservations or advice that you have?
That is a very loaded question.
Okay.
But I think for ODPP, I think we'll discuss our mandate.
Yes.
And as a country, we operate under a constitutional framework where the Constitution has actually properly delimited roles of different actors. So it's not necessarily a power struggle in terms of diversion, but in terms of what does the Constitution say, what has it delimited roles to the different actors. So I think for us, in terms of the reservation, you talked about ODPP, but the reservation really is an Article 159 in terms of the parameters in which AJS or alternatives justice systems can operate. Within the constitutional limits, the requirements of it all. So I think for us, what is it called? Reservation. It's not a reservation like ODPP. I think we just operate under constitutional framework, and Article 159 has given us what reservations are there in terms of alternative justice system. Of course, ODPP recognizes quite clearly diversion. I think we actually have a policy, so we can't actually say we have any reservation on diversion. We don't have any reservation on debargaining. We actually very much lead in terms of that from 2008, since it was put into the Criminal Procedure Code. So I think we say that there's no provision really that elevates AJS, more than the traditional criminal justice system. At this particular point. And I think for us, we will continue implementing our mandate and our powers. We can still, we have a power of even directing the IG to conduct investigations Under the Constitution, we do have our powers, so we continue to act within our powers. Even within the Children's Act 2022, we still continue to act within our powers. We institute these cases and we will undertake these children cases. However, I think it's the ODP position that AJS is a civil, is in the purview of the civil law. And there's no AJS within the criminal law, I think, as per the ODP's position. So I think I've just come here to present this position.
All right, thank you. Thank you, Linda. So please prepare your questions as the participants. I will ask the last question to UNICEF. What role, if any, do you think UNICEF and other development partners have in implementation of diversion and scaling it up in the counties in Kenya?
Okay, thank you. So did you get the question? The question was, what's the role of developing partners support the scale up of the diversion? So if this scale up means funding for the program and that's the development. So do you agree? So the most important thing, as you know, the aid environment, so it's news everywhere. But also what development partners put to the government, it's tiny. So compared to the government budget. Then also the police has mentioned about the budget. So the budget is the most significant policy that determines priority and also success of what the value you are promoting. So then I think this is where this is the problem lies, right? So then what are we doing on that? So first, do we know how much budget do you have for each activity? Do you have any analysis? How much that goes to children? And what sort of public financing work, like advocacy, what we have taken? I think this scaling up is really, so we need to challenge ourselves. This is also where we need to come together. So to talk to National Treasury and then all of these, most senior, the highest of each agency, so to really push. So for example, DCS has put 50 additional student officer in the past 2 years. So then they've been very active to pushing, engaging parliamentarians. So I think all of us need to embark on that. And also the probation, for example, it's been historically well funded, right? So the national budget is quite strong there. Basically, we need to start with analysis. If we said if anything we can support, so we can support this kind of analysis. We can support a little bit of putting venue together, or maybe a little bit of small policy we can do. But this is really the responsibility of the government of Kenya.
Okay, so as we prepare, I think Secretary, you can help me to take the microphone round, but just maybe one thing that you can say is the representative of your agency on ensuring meaningful participation of children in plea bargaining and diversion. Just a second.
Okay, thanks. Before I answer something on support CPUs, because resources in Nakuru, but currently is used for entities. So that is the moral. And I think even as you see for support, we need to also put in proper use of this. Because we get funds, but these funds move. So what happens in terms of sustainability of these structures? And to ensure that we have meaningful participation of our children, of course participation is key, involving our children, sensitizing them. We know most of the time they are supported or represented by advocates, but do they really know what exactly this is? So we can't
that is going on with this particular child. We look at the children officers' reports, which actually give us very good recommendations in terms of these children. Even in terms of plea bargaining, ensuring that before the child even appends the signature of the plea agreement, they know what it is, they know what they are accepting. Because the plea bargaining also has some conditions. I think that children need to understand. So in as much as we are negotiating with them, a legal representative, also ensuring that the child understands before they commit in terms of the plea agreement, they understand what it is that they are signing. And that's why there's a provision for a legal representative to sign, and also a provision for the child to sign, also for the ODP to sign. So before we present this document, ensuring that we know that the child has participated.
Thank you. And in the Directorate of Children Services and the State Department, we're still getting used to that. We need to provide an environment for children to express themselves. Sometimes that has been missing. Create child-friendly spaces, because sometimes we put our children in places where they're not able to express themselves freely, and then use age-appropriate methods like drawing, child therapy. We listen to many here. Sometimes the children go to court and they cannot express themselves, and then, like Crip said, a lot of sensitization, so that the children know about our laws, about our policies, and what it is that we're discussing. Rosaline, before we go, I just want us, before we leave this panel, can we just look at children officers and maybe other agencies are looking at the version, like the level, the playing ground is not level. We are feeling, and I say this respectfully, that it's like the version belongs to the DPP. So children officers feel they don't have so much of a role to play. They still feel like it's more of a judicial process. The protection and care file has to be made by the Directorate of Public Prosecution. And they're just feeling that, they don't have so much of a voice in the version. So maybe we can talk about it now that we're here. Thank you.
Okay, thank you so much, Anne. I don't know if police DPP have something to say about that, but tomorrow there is a roundtable discussion and a call to action on diversion, AJS and child justice. Juliet will be facilitating, Juliet and Karen will be facilitating that session, where we will delve into the details, but I'll welcome Linda to say something about that. And then police as well, you can mention something about that as we move forward. And I welcome any sentiments from the participants as well, so that we can see. We have 20 minutes. We have 20 more minutes.
Thank you, Leslie. Currently within the police we have we introduced what we call trauma-informed investigative interviewing, just to make sure that we remain sensitive both to victims as well as the suspect, and make sure that we avoid re-traumatizing throughout the criminal justice system. Then secondly, maybe just to respond to my sister, is that there are procedures towards establishment of CPUs within the police. Now, if you go at county level and establish the CPU without the knowledge of police headquarters, then we are not aware of that during monitoring and evaluation. At some point in Diani, there is an NGO that supported CPUs with beds, laptops, and what, and all of them were taken by police officers. But we had to recall them to provide the same. Now, if in Nakuru County we are not aware of that, we don't have any inventory of the items at police headquarters, then it becomes difficult for us to do monitoring and evaluation and make sure that the CPU remains functional.
Okay, so I think in terms of that question for the role of the children officer in diversion, I would say the children officer has the biggest role in diversion actually. If you ask me, Nyaranga, I think she can concur because she's given the experience. The children officer, I even think from the Children's Act, and even from other jurisdictions, we've been told Malawi, Australia, we've looked at South Africa. They start from the beginning, that is at the investigation stage, where they can offer information throughout this process, they get to interact with this child, get to give us the position of, actually they play also the part of, I would say, a psychologist, a guardian, together as the rehabilitator to this particular child, because they have to understand the needs of this child so that they can give a focused recommendation. At the end of this process, it is the children officer who will do the option. If anything, the children officer is the one that will lead in terms of, we think this would be the best option for this particular child. We think it is counseling, and we think this is how this child should be counseling. Where is it? And that's why we talked about programs. I think the biggest issue with diversion is not really about the power struggles or anything. The biggest issue is in terms of programs. I think if we had programs, even from whatever level, you just, say the children office has counseling, isn't it? And we take you for counseling. The children officer has a program, that they run in terms of skills development. And this child goes through this particular skills development. So I think for diversion, the children officer actually plays the biggest part, because you are from the start and you will finish with this particular child. So I think it's about understanding the role of the children officer, understanding your role within the process and within the system. I think you play the biggest part.
Okay, maybe just to add on that is that maybe DCS is so different. Yes, we have children also who are handling one and two sub-counties. Sometimes you have a child within the CPU, you try to reach out to them. Sometimes they are tired, they are overworked. So I think that we need to recruit and make sure that we are able to support each other.
And Linda, maybe just to clarify on diversion, since there's diversion for children and there's diversion for adults, when prosecutors are handling diversion matters for adults, I would imagine there will be diversion programs even in cases of adults. So how does that work? So that we have an overview of the new provision in children matters and how actors will be working together.
So in terms of
diversion. So diversion for adults, how does it work really? And the diversion programs they are referred to.
Our policy is in different categories of same offenders. So we have children, we have persons, elderly. We also have the elderly, of course, we omit crime, I think we've seen. We also have persons with mental, enabled differently. That's what they're called. They are persons enabled differently. And also for, just general adults, who've committed, say, petty offenses. So like traffic offenses, simple stealing, things like that. How do we divert them from the criminal justice system? So essentially, even for adults, we have to, of course, the file is brought to us, isn't it, with the offense. So first of all, we have to look at the offense. We have to look at the age. We've even done diversion for the whole world, anti-corruption matters. We've been able to divert anti-corruption matters. So, and even plea bargaining, we've been able to even bargain terrorism, all these kind of offenses. So once the file is brought to us, we will look at the offense, we will look at the acceptance of responsibility. It's still a key part of diversion. For all categories, they have to accept responsibility. And then we will look at programs, so either offered by probation, either offered by, a lot of times we even go to civil society. We used to have civil society organizations that are linked to us where we just make the decision. Our work is not to provide programs, our work is not to provide options. We refer. So we'll refer to DCS. Actually, we do a letter, DSCS, or we can call them then proceed with a letter. We actually had DCS coming to our offices at Fakati, where we've sat with them. They've told us this is what we think we can do with this particular child. And we just write a letter to them that continue. This matter is diverted, continue with the program that you're willing to undertake for this particular child. So I think even for adult offenders, there has to be the acceptance of response. There have to be the programs. There has to be restitution, because most times you'll find that an offender will choose to pay back, isn't it? Maybe it's stealing, they wish to pay back for this type of crime. So it's an, maybe it's a what? Assault, you know? They wish to probably do an apology. So we let them do the apology. And we actually do it within the decision to charge, because we can institute or not institute. So we actually look at it that aspect, that we can take you to court, or if you accept this, we can divert. But most times it's just a recommendation for other people. And I think world over that has been the scenario, that the DPT recommends, then the other actors just act like this case, continue with the programs. We don't provide options. Just let us start.
And you want to say something? Let me open, we'll open the plenary. So let's have that side, Patricia and Juliet, and then we'll have the department. Anyone else? Yes, Madam Nemamo, Dr. Nemamo. Yes? Wow, okay, 5. At least 6. Okay. I'll start by appreciating the panel and the time they've taken also to prepare the presentation. Maybe for just clarity, okay, my name is Patricia. I'm an advocate. I practice in Nairobi, and defender of child rights and children in court. So what I think, having listened to each one of you, what I've found is that there is not been a discussion on the power of the court when it comes to diversion. And this is usually in section 231 of the Children Act. So if you look at section 231, and I'll read it, because I think it's extremely important. Upon ordering diversion, the magistrate conducting the inquiry or proceedings shall identify a children officer, a probation officer, or any other suitable person to monitor the child's compliance with the identified diversion option. And these diversion options are in section 230 of the Act. Now, why I'm emphasizing this power is because it is not, and I think that was raised by Anne, regard to the role of children officers. It is for the children officer to prepare a report, not for the other actors, not for me as Patricia, as the counsel for the child, not for the ODPT, so the court. And then after this, the court is the one that will determine whether or not the pathway is diversion as per the Act, because that is the guiding act when it comes to matters relating to children in Kenya. And it is what interprets Article 53 of the Constitution. So, and you'll find that the Constitution doesn't mention diversion. Diversion is mentioned in the Act, the Children Act. So, when you think of now the process of diversion, when you've done the preliminary inquiry, and this is usually now when the matters come before magistrate, the preliminary inquiry comes, the court then, after the preliminary inquiry, under section 231, either recommends diversion, number 1, or that the matter will trial. That is the Act, that is what it provides. And so, the role of the children officer is to provide the assessment of the initial part, and also to provide a report for the court's consideration. And this is also in line together with the probation report, as psychologists report to the court as being fit. It
Okay, then, yes. Okay, let's have Juliet and then we'll have responses.
Good afternoon. My name is Juliet. I am a teacher of the law and a child rights lawyer. So I have 3 questions, so maybe more in the comments. Mr. Song, thank you for your presentation. I was wondering if we have still the effective section 218 that talks about when an officer arrests a child, you're required to write a notice, the children officer, because you see, I took note of that because Anne said, you know, the place of the children officer when it comes to children in conflict with the law and that trial process, it feels like the children officer is invited much later to the table. Yet the law requires that once upon arrest, the notification should go to the children officer and the parents, and then the preliminary inquiry kicks in. So, the first question is to Mr. Song, and then also just say and emphasize what Anne said, that the CPUs are for not for children to enjoy their rights. It is not and I know because I have had the opportunity to visit a lot of CPUs that the police are involved, like the in charge, will be involved in the development of that child protection unit. So my worry is that the police officers later on come on and say that this was not built to standard. Yet the police were involved as members of the CUC. So where is the disconnect? Is there even a plan, for example, maybe from headquarters that tells us this is how a CPU should look like? Okay. And then secondly, my comment is to Linda, actually it's a question. Since 2019, since you launched the policies, do you have maybe data and successes on, especially successes really, I think that would be important, on the diversion that you have undertaken for children, the programs that the children have undertaken, and the success of that? Or are you seeing, children, are they recidivizing because of lack of programs? So I think that would be really important so that when we are adopting either the court-led process or the DPP-led process or the children officer-led process or the police-led process, we have data to back up what is important and why is that. And then finally, I just want to say this. If you look at section, I think it's 227 on the objects or objectives, yes, objects of diversion. I don't go to court. I'm an advocate, but I don't go to court. So everywhere I go, I just say, I'm here listening for the child who will not be able to discuss these issues. And so I don't have mandate. I can't stand here and say, I have a mandate. Like the DPP will say I have a mandate. The court will say we have discretion. The police will say we have power. The children don't have all that because they sit, they don't, she's here. She doesn't have power. Right? But diversion was not meant for us to flex our muscles. Diversion was meant for her, for your son and your daughter in the house. That is what diversion was for. So if we look at the objectives, one is to make use of the alternative methods of holding children accountable, and hence AJS, for example. Yeah? Promote rehabilitation of the child. That's why I'm asking anybody here who's doing diversion or has a diversion program, give us data. Because I work in policy issues and this is what would advise the best policy. It is to provide an opportunity for those prejudicially affected by the unlawful conduct of the child to express their views concerning such conduct. This is the voice of the victim. Today Dr. Kot talked about the child offending the child. So this is where the other child also gets to say, this is how this has impacted me. And then promote reconciliation, so restorative justice. Because at the end of the day, the 17 or 16 or 14-year-old who commits an offense will eventually come back to this world to stay with us. So how do we promote reconciliation? And finally, is to minimize stigmatization of the child. And so, I don't know, me speaking on her behalf, when I was a child, I said I want to be a voice for the child. So me speaking on her behalf, I wanted to say where does her mandate come in here? When we all flex our muscles. Thank you.
Okay, so
those are two questions, or a couple of questions from two participants. Let's get the responses and then we move. Okay. From the three. Okay. The third person was, yeah, we can have her, and Dr. Nyamamu was. Dr. Nyamamu? Yeah, okay. Let's move this way. We have 10 minutes.
Thank you so much, panelists, for enlightening us on what diversion is and plea bargaining. My name is Dr. Miriam Nyamwamu. I come from the Kenya Results. For maybe for the benefit of the participants, we also own children in our institutions, we own them in the postal institutions, and we also have the YCTC. So I don't know whether we have a role in diversion, but I know we have a very important role because we also own remand children at community YCTC who are supposed also to benefit from this program. Okay. My first question goes to LRF. I know LRF has been working with the Kenya Results for a long time. You said that you've sensitized at least 6 counties across the country about diversion. So I want us to enlighten us on how you do it. Do you do it in individual, maybe from one house to another, or maybe it's the community or the GAO? Then another question goes to ODPP. Madam Linda, thank you so much for enlightening us on how our children who are in conflict with the law have benefited from diversion. You mentioned that there's a challenge of programs. And since you are a practitioner, can you also inform us the programs which can be effective for children so that they don't reoffend again? So that in the future, maybe when a magistrate makes an order, he or she can pronounce that let these children, maybe the child be taken either to rehabilitation, to a counselor, or to maybe a psychologist. Then the other question goes to Madam, I can't pronounce your name very well. Our Madam's sister, what's her name?
Eri.
Yeah. Thank you so much also for enlightening us on what's happening in other countries. I want you to inform us about the best practices either in your country, the programs you have for children who are in conflict with the law, so that we can also be able to implement in our country. Thank you so much.
Thank you so much, Dr. Nyamamo. So, let's. Okay, just ask him then. Because we have 7 minutes.
Okay, thank you so much. So my question goes to Linda, my former colleague. Yeah. So when we're developing the diversion policy, one of the things that is provided in the diversion policy was interagency collaboration with different actors, and it's quite unfortunate that we're seeing our role as DPP is to give recommendation but do not follow up. So what is the whole essence of diversion? Because the purpose was, if I'm sending you for maybe psychosocial support, or I'm inviting you to for rehabilitation with the different means. So if we just divert and say I've diverted, but we will not have like proper coordination, because it shows that one of the challenges is proper coordination. So I think what we need to come up with like tomorrow is how do we coordinate with the different actors who are supposed to now play the other role, so that if we saying that I'm diverting, then who are these agencies around who can be able to pick up, so that they can be able to actually give a holistic approach to this child who is in conflict with the law. For instance, can you have MOUs with the civil society? Can you have MOUs with the government? Like we want to have MOUs with the Ministry of Health in terms of psychosocial support. So I think the question by Mishana comes in handy. What have we done since 2019 when we developed the policy? Because the whole essence is, can we have even MOUs with different actors who can pick up this child, so that because the whole essence is, can this child now be rehabilitated or granted psychosocial support or taken through training? So what have we done in the last 6 years or 7 years of the ODPP diversion? On the second issue, I think Linda was saying that AJS is only for civil. I think we are mistaken on that. because remember, here we are talking about ODPP diversion, which comes in when somebody has come in contact with the law or in conflict, either in contact or in conflict with the law. But the whole essence we are trying to see what mechanisms can you have with these children so that they don't even come through the system. Because if you go to certain police stations or holding facilities, they don't even have facilities for children. Go to Capitol Hill, it doesn't even have a holding facility for minors. Go to Langata. So we have challenges even with holding facilities. So the whole essence is how do we handle these children who are in conflict with the law before they even come to ourselves. They come with the police or with the DPP. So that's the whole conversation. So the conversation when we were developing the diversion policies, we have even pre-plea diversion. Pre-plea diversion means before this minor or child is brought in contact with the police or in contact with the DPP. Then we also have the post, that even if this child has been, told that you're going to be held somewhere, now prisons come in that we can be able to even work with different actors to deal with the realization of this offender. So there are 3 levels of diversion, and I know that the Children Act only looked at when the person has come to court, and the DPP looks at when now I as the DPP is looking at this file. But remember, we need to see how do we handle these minors before even they come in contact, because we are still way back in developing structures and policies that are dealing with minors before they come in contact with the law. So that's the whole challenge that we have, the elephant in the room. And DPP has a mandate under Article 11. Article 157 sub-Article 11, looking at the best interest of everyone, not only just the minor. So in looking at the best interest of the minor, how do we deal with this aspect before even the child comes to court? And that was the whole essence of the Children Act.
Right. So there are many questions. So let's start with Anne. Do you want to start? Okay, Anne, and then
Thank you very much for your questions. I just wanted to respond to Dr. Namam, who was saying maybe we can inform which is the best program for children. Actually, we realize it's not a one-size-fits-all. When a children officer does an assessment, then you advise the coach to be looking at what are the needs, the immediate needs of that child. And that will guide the program that you put in that child. So it's not, you can put all these children in this program because it's working. What may work for child A is very different from what will work for child B. Thank you.
Police.
Thank you. In form of arrest, yes, before we make any arrest of a child, we always reach out to the children officer unless they are not available. If they are not available, then most of the time we have to work with probation, work with the social workers, we involve children's homes, just to find out, because some stations don't have CPUs. So if you are going to arrest and yet that station has got only male lockup places and female lockup, there's no lockup places for juvenile. So it becomes a challenge. So we always reach out to them. They always share which CPUs has got space, which children home has got space and can accommodate that child. You will find that there are children homes that will not accommodate children who are in conflict with the law. Yes, so they will always share that information and we are working together with them. Then secondly, in terms of establishment of CPUs, yes, we have a plan at police headquarters. We've created awareness to our police officers and especially the commanders that before anybody establishes a CPU, they need to work with the police headquarters. But again, you know, we have 3 police headquarters. Yes, we have at the IG's level, we have at the Kenya Police Service level, and we have at DCI level, and we have at APS level, Administration Police Service. So all stations are domiciled within the Kenya Police Service. So when they go to the IG and sometimes they find somebody there, you find they go on establishing what? CPUs, like Honorable Pasaris supported some establishment of CPUs, and all of them are containers. And yet we gave out the plan, but you know, again, you may not challenge the politics. You know, do politics in Kenya. If she's able to interact with the IG and IG has given him a go ahead, we may not stop at our.
Okay, maybe there seems to be need to standardize. I remember earlier this year we had a trip to Lodwar, and they also have an issue with the child protection unit, how it's constructed. So there seems to be no standardized requirements for what the CPU should have. I think there's a floor plan of what it should have, but in terms of how it should be constructed, I think there's a gap there in terms of standardization. So maybe something. Do you have something to say, Mildred, Eric? So then we end with ODDP.
So there was a question to Legal Resource Foundation on how we do sensitization. So what you do in the counties that you work in, we train the children court users committees first so that then they can appreciate this, because not everyone appreciates what the version is at that level. Then we go ahead and establish the version committees. So these are specific members who have been drawn out of the children court users committees to champion diversion processes in that county. So this committee is mandated with sensitizing, but also ensuring that the county implements diversion processes within the county. We also do sensitization through chief barazas. So we have paralegals in our counties, and they go to chief barazas to sensitize communities on the role of diversion and how our children are processed in the justice center, and how the role of the communities themselves in this process, because they have a key role in that regard. We also train our children in the remand homes, and we also visit schools to just sensitize children on their rights. And basically we've done like versions of the Children Act for them to appreciate what is the need for them in these laws that we churn out within the sector. We also do train National Police Service, the police officers, for them to appreciate what their role is in this process, how they can also advise the ODPP in matters of diversion, and actually basically training them on special needs, because we've done training on special needs for officers to appreciate what kind of a child has been presented to me, do they have underlying challenges, how does that speak to the diversion conversation, and how they can use that information to instigate or probably just facilitate that process. Ngao, of course, are very key, because they also have a role in terms of reintegration of these children back into the society. So the treatment plan, how is it anchored at the community? Most of the time the entry point is not the chiefs, the assistant chiefs. So how are they prepared, how are they skilled to ensure that they have the requisite knowledge to help our children, or anchor our children when they are integrated back into the society. But also just to speak on the role of children officers, for me I think where we do not have designated children courts, we still do not have PNC files, and that is how our children officers are brought on board to take it to participate in the children in conflict processes. So for us, I think it's a call for everyone here to just ensure that whatever course that we implement or work in, how do we ensure that these courts open PNC files, and especially for non-designated children courts, to ensure that every magistrate has a PNC file, is a protection and care file, to ensure that our children officers are involved in matters of children in conflict with the law. So that for me, I think, is what I can say. Thanks.
Thank you so much, Mildred. And I think also to share, I'm not sure who, I think it's Dr. Nyamam who asked. I think the sentiment is there's training going on and there's sensitization ongoing on diversion, but there seems to be no coherence in terms of coordination, the roles, the programs. So which one should go first? The coordination aspect, the roles identification, and then the programs as well on the ground. Then the sensitization can come, because there seems to be still a gap in terms of what should be done with regards to diversion. So the sensitization, maybe the resources should be going into first identifying or having a consensus at the national level and policy level on diversion for children. Then okay, can I give Ruth has something to say about the diversion mapping? I think there's an exercise there. She'll mention that, and then Linda will close. I'm so sorry we are not able to take any more questions, but there will be a session tomorrow on diversion as well, and then we can continue with that conversation.
Thank you so much for this opportunity. I appreciate. My name is Ruth Areli from the Directorate of Children's Services. And quickly, I just want to make about 3 comments. The first one, I want to appreciate what Patricia referred us to. Actually, that was in my mind to say, because when we're looking at diversion, let's already look at the power of the court in diversion, and looking at the court having received reports from the various stakeholders at preliminary inquiry, then it's the court to either proceed and order diversion in various forms. And one thing that I'd like us to appreciate from the start, again, one of the options that the court has, according to the Children Act, Section 232, is also family group conferencing, which is part of the diversion process and part of the PI as laid out in the Act. And the key role the children officer will play as directed by the court to convene that conference, and the number of people and the kind of parties to be present is stipulated there. And again, important to mention is the fact that this report of the group conference will go back to the court again, and then the court will look at how the discussion has gone with the child, and then divert that child and give that order. Again, I also want to make a quick comment on what she said. When we are looking at alternative justice systems, we are also focusing on putting in place programs to preempt commission of crime, so that we're not just looking at waiting for children to commit offenses that we divert. So again, programs at the community level to prevent offending are very important. And at this point in time, allow me to mention that the Directorate of Children's Services has deliberately made an effort, and we are at the formative stages of putting together a framework. I don't know that we call it a framework or a strategy to map out programs that exist in various counties that, upon recommendation for diversion, when we receive a child that is being diverted, we have those services available. So ultimately, we intend that we shall have a directory of services available all over, and then also the programs that we're going to create, because we have to establish other programs relevant to support the children who are placed under diversion programs. So that is one thing that we want to do. And I'd like to mention that because all actors in the justice sector have a role, I want to appreciate NCHA, the fact that they appreciated that the framework for diversion and identifying each party's role is important, so that we are all not developing our own special roles. And lastly, the issue of appreciating the role of the National Council for Children's Services in terms of regulation of children in this country and oversight. So when it comes to specification, for example, for CPUs, rescue centers and all that, we need to have that in place, and I know it's a conversation that has started. So the National Council for Children's Services have that responsibility. And I also know that they have mapped out the roles given to each agency in an implementation framework of the Children Act, whereby they will now hold each agency accountable. If the IG requires to deliver the special police unit and the special child protection unit, then they have the power to come to you and say, hey, the law says you have to have this. So it's up to you to go out of your way, go to the private sector, go to the treasury, go everywhere, and institute those things. So just to appreciate that the National Council for Children's Services has a big role, and in this conversation, they need to be brought on board. Thank you very much.
Thank you so much, Ruth.
Let's have the final word and responses from Linda, and then we close.
Okay, thank you. I think I have a few questions from the plenary. So I'll start in terms of the role of the judiciary. The role of the judiciary is was provided for under the Constitution, isn't it? We cannot make orders. The final order, the final decision is not an order or a decision for the ODP. That is the role of the judiciary, making of the orders. However, we do have a role of undertaking criminal proceedings. That is still a constitutional role that the ODP has been provided or been given. And I think both of them can work hand in hand in terms of diversion. So I'll go to also section 228 of the Children's Act, which talks about a child's appearance at the preliminary inquiry shall be regarded as his or her first appearance in a court as contemplated in the Criminal Procedure Code. So we are not, the Children's Act is not working in a vacuum. It is also working with the, what is it called, the Criminal Procedure Code. And we do know the procedure for trial. If this is the first meeting as contemplated as per the Criminal Procedure Code, then by the time we provide this charge sheet or this document to the judiciary, then that means trial has started. Because what is a criminal proceeding? Criminal proceeding starts at trial. And if we are instituting and undertaking these proceedings, then that means trial has started. And the CPC is being recognized under the Children's Act. The other question was with regards to, I think I've talked about the court. Of course, they can make orders. We do not make orders. If anything, we present our case to the court for the court to make the order. We have never even contemplated of the same in the diversion policy and in the guidelines. The guidelines are very clear. We go to court. That is post-charge diversion. We go to court, we present whatever findings we present. The children officer presents their finding, and the court will make an order. However, we do undertake the role. We can say, of course, we want to terminate this proceeding, isn't it? And that is us, that is the ODPP, isn't it? But we cannot be told, terminate this proceeding. I think that is where we need to make the distinction. In terms of programs, I think prisons asked about the programs. Of course, the programs are the ones contemplated under the Children's Act, which are still the same programs that had been contemplated under the diversion policy. So counseling, all these things, supervision, rehabilitation, we even have issues of drugs, isn't it? Which are cases that should go actually for diversion. Those are not cases we actually should even be taken to court. However, we have a drug rehabilitation program in this country for children. We do not have. So I think those are the programs that DCS should sit down and try and come up with. When we talk about vocational training, are we talking about TVETs? Really, can we take children to TVETs? So those are the questions DCS should be asking themselves. So that there's a child who is stealing, but why are they stealing? It's because they don't have an education. Can we take them back to high school? Probably not, but we can take them to TVET. So those are the MOUs DCS should probably be coming up with. In terms of mandates, we've been told about mandates. We keep on talking about mandates. But essentially we have, and I think the term systems has been used by everyone. Roslyn has used systems. Ruth, you've talked about system. It's a system, and in this system there are actors. And in these actors, and that's why we are here, isn't it? It's because we have different mandates, isn't it? I'll not be here as ODPP if I didn't have a mandate in the criminal justice system. So we are not, if anything, I think the ODPP has been on the forefront. We have a children's division since 2014. We have the diversion policy. We even have a guideline for children. So we're not saying that the ODPP does not understand how to take care of its mandate. But we, of course, work in a system, and we want the system to work. And we know the role of the police in this system. We know the crucial role of a children officer in this system. We know the role of the judiciary in this system, but we are still in this system. The ODPP is there. So if it's a system, then make the system work. Make the actors work so that we say we are in a system. And yes, mandates will also apply because it is a system. In terms of follow-up arrest, I've been asked about,
isn't it? But my question is, why are the police arresting children for petty offenses? Why are they being held in CPUs for petty offenses? These are children who actually should just be given police bail and coming to court or to, DPP or wherever they're supposed to come, to the children office, Why are we arresting children for petty offenses? Why are they in these CPUs for petty offenses? I think that should be the first question. That's the first question we should ask the police, because it should be a guideline, that children, just maybe we can say maybe terrorism. We can pick out specific offenses, where you think probably there's a danger, isn't it? A child can be kept in a CPU, but not all. The practice of taking a child and taking them to a police station is a practice that should stop. In terms of follow-up, so in terms of even how we are dealing with these children, we should be dealing with these children at home, not at a police station, not at a remand facility. They should actually be home. In terms of follow-up, yes, we do follow-up. I think for us, the diversion guidelines, that's where we have monitoring and evaluation framework in our policy, is that we need to do follow-ups. Once we give LRF maybe a case, they're supposed to just give us a report. And we've even had reports from even children of So what do you do if the child, has run away and is not maybe ensuring that they're not, following up on the system, on the diversion programs? Of course, we can ask the police to rearrest, because this is a child who has committed an offense. So there is follow-up in these cases. In terms of successful diversions, we've had a few. We've even had a few for even, what are they called? We've even had, you see, the fire incidences. We've actually had a case for, and I think it was in the Western region, where a school was banned. And the people, the prosecutor didn't want to charge this child. So she was asking, how can I assist this particular child? Yes, it's a fire incident, but fire incidents sometimes, they are motivated by a particular thing. Maybe it's food, I don't know, it's, different things. But of course, we don't want to spoil for this child's record. So she was asking, what can we do with this particular child? And no, it's not their LRF. They're called, there's a, Sefa, sorry, it was Sefa. Sefa actually picked up the case. The child was housed in Nairobi, that's where the parents were, and Sefa was doing supervision for that particular child. And they actually gave us a report in terms of this is what happened to this child. Of course, a fire incident case, that's a serious offense, isn't it? Those are the cases, mnasikianga polisi wakisema, what are they called? No, not even, the poster, it's called what? There's a poster they usually used to name. Well, to do what it was asked. You've never seen the DCI poster of Salime Ambieni Wazazi or something of the sort. We used to have a lot of that because of these fire incidences, but we thought probably there's a different way of dealing with these particular children apart from always taking them through the criminal justice system. We helped in terms of diversion, and SEFA was, and it's like LRF. It's not a government institution. And right now we're trying to do MOUs. We are in the process of talking to, it's high level, talking between our Secretary of Public Prosecutions and she's the Secretary Probations in terms of an MOU, in terms of how we can be sending some of these cases to probation, because that's where we've had a bit of a struggle. But even if you look at our ODCP Act, there is a cooperation, a duty to cooperate. Section 17 of the ODPP Act. If you look at it, it has a duty to cooperate. And not just, it's for actors. It's for the DCS, it's for the State Department, it's for the State Department, it's for probation, it's for everyone. The police, a duty to cooperate. So I think I've talked a lot. I think there's also going to be a session tomorrow on AJS and criminal matters, which I think can answer some of these other questions that I'm not dealt with. But this is a system. At the end of the day, this is a system. We are helping these children as a system.
Thank you so much, Linda. So as a facilitator, I cannot really push to ask a lot of questions, but tomorrow we'll have a plenary discussion. I think a further one, more detailed one about diversion. But there seems to be several things that are coming out. One is the roles and responsibilities of actors. With regards to diversion, I think Linda has mentioned now is the criteria of the matters that will be considered for diversion, like petty offences. And then the third one I see is diversion programs and clarity on that, because there has to be programs. And then I think the policy framework. So we do not have judiciary here, but it doesn't mean that judiciary doesn't have a role. Sorry. I think tomorrow there will be, we don't have judiciary here on the panel, but it doesn't mean that judiciary doesn't have a role. It definitely has a role, but I think we have a consensus that each and every agency has a role, but we just need to be clear what is that role, and also differentiate, because for me, I don't know if the children are understanding, there needs to be a difference between, between the judicial process, the normal one, and diversion. So when we're talking about diversion, and we're saying that diversion is going to be used as a measure to ensure that children do not enter the justice system as usual. So what is that instance that they don't enter the justice system? So just making a difference between those two processes. So having a difference between that. I'm so sorry we can't pick any question. Okay. Yes.
As the fact that we've involved children in this setup today, the language is so jargon for them. Actually, she just asked me, what is diversion, before you even answered. So when you're making these systems and having these sensitization programs, can we make it child-friendly for them to be able to understand as well, so that they are not just being agreeable because they've been caught in an offense and they are feeling guilty, or because two adults are talking to them now they feel they cannot speak, because most children are usually very close off. But we make the language to be child-friendly for them to be able to understand.
Thank you. Yeah.
So then I think we are done. So please let's give a round of applause to the panelists. Have a good day. Lunch is served. We will move to the ground floor. Lunch will be served there. There's a restaurant on the ground floor, so we'll move there.
Oh, okay, yeah. The section is diversion is not only for the offenses, it's used for the serious offenses as well. So please, like when we talk, please be careful. So we have to really, needs to be kind of, stand on correct thing. Yeah. So then, for example, also CPU is really not about specification as such. Even CPU is there in the list that they are not using it. Then even CPU is there, children are there for a year, an year and a half. So it's